Companies Act, Section 271, circumstances in which a company may be wound up by the tribunal. Section 271 of the Companies Act, 2013 lays down the specific circumstances under which a company can be compulsorily wound up by the National Company Law Tribunal, NCLT. This provision identifies a limited number of critical grounds on which the tribunal may intervene to dissolve a company. These grounds address both internal decisions of the company and external regulatory or public interest concerns. A petition to initiate such winding up proceedings must be made under Section 272 by eligible parties, and the tribunal will evaluate whether the legal grounds under Section 271 are satisfied before making an order for winding up. Detailed grounds for compulsory winding up by the tribunal. A company may be wound up by an order of the tribunal under the following circumstances. A. Voluntary resolution by the company for winding up through tribunal. If a company has passed a special resolution, requiring approval of at least 75% of the shareholders present and voting, stating that it should be wound up by the tribunal may proceed to wind up the company. This provision empowers companies to initiate their own dissolution through judicial supervision when they determine that continuing operations is no longer viable or desirable under the law. B. Activities prejudicial to national and public interest. The tribunal may order the winding up of a company if it finds that the company has acted against the following interests: the sovereignty and integrity of India, the security of the state, the friendly relations with foreign states, the maintenance of public order, or standards of decency or morality. This provision aims to safeguard national security and public interest by allowing the closure of companies whose activities threaten India's internal or external harmony, stability, or ethical framework. C. Fraudulent conduct or formation of the company. Where an application is made by the registrar or by any person authorized by the central government through a notification under the Act, and the tribunal is satisfied that the company's affairs have been conducted in a fraudulent manner. The company was formed for a fraudulent or unlawful purpose, or the individuals involved in the formation or management of the company have been guilty of fraud, misfeasance, misconduct in performance of duties, or other misconduct. And the tribunal is of the opinion that, under such circumstances, it is appropriate and necessary to wind up the company, then it may pass an order to that effect. This clause functions as a safeguard against entities that have been used as vehicles for fraud or unethical conduct. D. Persistent default in filing financial statements or annual returns. If a company has defaulted in filing its financial statements or annual returns with the registrar for 5 consecutive financial years immediately preceding, this non-compliance may be treated as a ground for winding up. This ground aims to uphold financial transparency and accountability among companies and penalize long-standing defaults. E. Just and equitable ground for winding up. The tribunal may also wind up a company if it concludes that it is just and equitable to do so. This is a residual and discretionary power that allows the tribunal to evaluate cases where, although the specific statutory grounds may not apply, it would still be fair and reasonable based on the facts of the case to dissolve the company. Typical examples may include deadlock in management where the company cannot function. Loss of substratum, core purpose of the company has failed. Oppression of minority shareholders. Continued losses or failure to commence business. For more details, contact us.